MSW Media.
I signed an order appointing Jack Smith.
And nobody knows you.
And those who say Jack is a fanatic.
Mr. Smith is a veteran career prosecutor.
Wait, what law have I broken?
The events leading up to and on January 6th, classified documents and other presidential records.
You understand what prison is?
Send me to jail.
Welcome to a very special bonus episode of Jack, the podcast about all things special counsel. It's Monday, maybe Tuesday. I don't know when you're going to get this. July 15th, maybe July 16th. I'm Allison Gill.
And I'm Andy McCabe. Okay, we're bringing you this bonus episode because Judge Aileen Cannon has dismissed the case against Donald Trump in Florida on the grounds that the special counsel Jack Smith's appointment violated the Constitution. So we're going to talk about her ruling. We're going to talk about the precedent and the possible ways forward for Jack Smith and the Department of Justice. Until today, every federal judge that considered the issue, all 8 of them, unanimously found that attorneys general can appoint a special counsel. Judge Cannon has departed from that tradition.
Oh, yeah, in quite spectacular fashion. And we do actually have a statement from the special counsel's spokesperson on what they plan on doing. But let's cover what her ruling says. We'll start with what her ruling says. We'll talk about a couple of great points made by some experts that are close to us in the podcast and that we also follow on social media that are great experts and con law experts and law professors. And then we'll talk about the options and the ways forward. And we'll give you that statement from the special counsel's office on how they plan on proceeding, or at least how it appears they will proceed. So, Andy, with that, how about you kick it off with some of these really amazingly unprecedented and hugely long run-on sentences in Judge Cannon's ruling.
93 pages worth of run-on sentences. So if anybody's really digs run-on sentences, this is for you. You should download the PDF immediately. Okay, so let's start with the beginning, which cuts right to the chase. Former President Trump's motion to dismiss indictment based on the unlawful appointment and funding of special counsel Jack Smith is granted in accordance with this order. The superseding indictment is dismissed because special counsel Smith's appointment violates the Appointments Clause of the United States Constitution at U.S. Constitution Article 2, Section 2, Clause 2. Special counsel Smith's use of a permanent indefinite appropriation also violates the Appropriations Clause, U.S. Constitution Article 1, Section 9, Clause 7. But the court need not address the proper remedy for that funding violation given the dismissal on Appointments Clause grounds. The effect of this order is confined to this proceeding.
That's an interesting statement right there. The effect of this order is confined to this proceeding.
Yeah, I mean, on one level, it's of course it is. She doesn't have the authority to make rulings on anything that affect anyone else. That's why, standard old district court federal judge decisions are not considered precedent of anything. It's not ruling law, right? As you're, writing a legal brief or something in another case, you might look at how other district courts decide an issue, and you might, if they're all overwhelmingly in one direction, as was the case here, you might cite to that kind of trend, but it's not technically a binding law because the district court is the kind of court of, it's like the entry-level federal court.
Yeah. Also, I had asked Joyce Vance a while ago, because I kind of saw the writing on the wall when she decided to allow oral arguments in a mini trial on this.
Mm-hmm.
I said, so when she dismisses this case, will that mean Jack Smith goes away in DC as well? And she said, nope, nada. She goes, never does a district court's judge bind any other district court judge from doing whatever they are doing. So real quick before we get into the particulars, listeners of this show probably were prepared for this day. And so I want to kind of give everybody almost a high five, because we've all been waiting for a reason to go to the 11th Circuit, right? We've all been like, she's going to dismiss this on something. It would have been extremely perilous had she waited until trial and dismissed it when it was too late to refile these charges. But she's kind of done what we thought she would do, which was either dismiss it on this or dismiss it on SEPA stuff, or make a egregious, clear legal error on SEPA rulings. We thought for a minute she was going to release all the witness lists and we would be able to go up to the 11th. So I really kind of want to, I hope everybody hops on board with me here in that, yes, this is ridiculous and unprecedented and stupid on its face, but also, yay, we get to go to the 11th Circuit, because it's kind of something we've been all waiting for. So let's talk about how wrong she is on this. What are your thoughts on, us finally getting an on-ramp to the 11th Circuit here?
I think that's true. I also think it's interesting too, because it's kind of, in that way, it's a departure from the way she's been handling these motions thus far, right? We always have had this feeling that she's been very cagey in her decisions, most of which begrudgingly accept the special counsel's reasoning on any given issue. But then she always, in motions that go the other way, she avoids the sort of permanent rulings that could potentially lead to appeals. But this one, man, she just took aim at the entire case and knocked it out, which is the essence of an interlocutory appeal. There's no other,
right.
There's no other way to handle this from the prosecution side. So there's no dispute as to whether or not it's interlocutory. It absolutely is. So,
and before you go on, it is important that we note that this dismisses the entire indictment against Trump, Nauta, and De Oliveira, the entire superseding indictment. And so it's all been wiped out. So, whereas before we were like, oh, maybe she'll sever Nauta's case and move forward with pieces of this or something like that. No, the entire indictment is dismissed. And that's very interesting, because she invited and nudged Nauta and De Oliveira to join this motion.
Right.
And they did. Just kind of like, and how we're going to get into this in a second, Clarence Thomas, when nobody asked him, out of nowhere, in the immunity ruling and his concurrence, nudged Cannon by saying, I don't think Jack Smith's appointment was constitutional.
Yeah.
So there's a lot of nudging going on in this. And the timing is pretty striking, too, the first day of the RNC.
Yeah. All right. So let's dig into the details a little bit here. She goes on to say in this extensive written order, the motion before the court challenges the legality of Special Counsel Smith in two consequential respects, both of which are matters of first impression in this circuit, and both of which must be resolved before this prosecution proceeds further. The first is a challenge to his appointment under the Appointments Clause, which provides the exclusive means for appointing officers of the United States. And we again have the cite here to Article 2, Section 2, Clause 2. The Appointments Clause sets as a default rule that all officers of the United States, whether inferior or principal, must be appointed by the president and confirmed by the Senate.
Okay, so a phrase that stood out to me here is when she says these two challenges, the motion before the court has two consequential respects, matters of first impression. They're both matters of first impression in this circuit. Can you explain what matters of first impression means?
Sure. So I think that technical translation of it is that it's a matter that has not been addressed by the court before.
By the 11th Circuit.
Yeah, but essentially it means by whatever court is saying that, whatever court is making that claim, essentially it means there's no precedent on the issue. It is absolutely never been ruled on before. This is the first cut at it. And she does specify that she's saying it's a matter of first impression for the 11th Circuit, which may be true, but it's kind of weird because it almost feels like she's setting it up she's setting up, giving herself kind of the permission to engage in this extensive, unbelievably detailed historical semantic analysis.
Right. Well, you guys have never thought about this before.
Right.
Yeah.
And completely ignore all the many courts, albeit not in the 11th Circuit, but other courts that have decided the issue. So I definitely feel like this thing is very intentionally written. And I think that's part of it. She's kind of
like
making
she's trying
a
to
case for herself as much as she is for the ruling.
Right. Like she's trying to mitigate removal from this case.
Yeah, she's
right
about
by saying like, hey, I have decided murder is not illegal. That's never been litigated in the 11th Circuit before, even though it's ridiculous. There's never been a holding in the circuit before. So kind of like the if I'm reading between the lines, she's saying, so you can't remove me from this case based on this because you've never had this question before you before.
Yeah, I mean, maybe she's going that far. It's hard to say, but I think she's definitely at least, in the least case, she is laying this out as a foundation to explain why she's going to go through this 93 pages of hair-splitting analysis. It's broken out like an outline in some places. There's bullet points. She's got tons of like law review articles that she cites to, and all kinds of claims of legislative history, and then other places where she explains you don't need legislative history. And then she cites to Webster's dictionary on all these the significance of past participle verbs in the congressional language. Like she's got to like justify why she's going to this incredible length to do this very, specific textual interpretation. When in reality, there's 8 other courts that have addressed this, have addressed the actual legal precedent, have addressed the relevant Supreme Court cases, which there are a couple, and come to the same conclusion. But she's going in a totally different direction. So I feel like this is part of that setup.
Right. It's kind of like, here's, if the 11th Circuit holds my finding here, then there will be precedent in the circuit. So I have to write it.
Right. She's
basically
trying to build a foundation, but anyway. So that's what matter of first impression means, but that's why I think she's going out of her way to kind of raise that issue early on. So she continues in the decision to say, both the appointments and appropriations challenges as framed in the motion raise the following threshold question. Is there a statute in the United States Code that authorizes the appointment of Special Counsel Smith to conduct this prosecution? After careful study of this seminal issue, the answer is no. None of the statutes cited as legal authority for the appointment. So, and then she goes on to say, the bottom line is this. The Appointments Clause is a critical constitutional restriction stemming from the separation of powers, and it gives to Congress a considered role in determining the propriety of vesting appointment power for inferior officers. The special counsel's position effectively usurps that important legislative authority, transferring it to a head of department, and in the process, threatening the structural liberty inherent in the separation of powers.
Man. All right. So the bottom line here is that because Jack Smith was not confirmed by the Senate, right? Because he was working for the Hague when he was picked up, that he can't be special counsel. That violates the separation of powers. Even though the special counsel regulations state that appointments actually must come from outside the government, which is what I was telling, Hunter Biden's lawyer, like David Weiss came from inside the government. John Durham came from inside the government. That seems to violate special counsel regulations. So she's kind of setting this new rule now that they have to come from within the government. They have to individually be appointed by the president and confirmed by the Senate. But what if you're investigating the president anyway? I think this is
confusing.
Really,
it's confusing because of the way she's presenting it here. Eventually, what she gets around to addressing the fact that the Appointments Clause, it provides 2 different ways for appointments to be made. One is the traditional way. The president nominates and the Senate confirms. So the Appointments Clause says in order for, the president has this authority to appoint people to take over government officer positions, and then they must be approved by the Senate. So that's one way. The second way is Congress can pass a law specifically delegating the appointment authority to either the president or a court or a head of an agency.
Right,
And
the
in
Attorney
this
General
case,
in this case, right?
The Attorney General in this case. And
But
she's
But isn't she also saying that even if that law were on the books, she would strike it down as unconstitutional?
I don't think so.
Because Congress would have confirmed.
No,
So-
because
well-
so she's saying there is no such law that specifically grants the Attorney General the authority to create this position.
Right.
Like there
but even
used
if
to be
there
a law.
was, but even
There
if
used-
there was, she's saying that the Senate has to confirm.
No, the Senate confirm is the first channel, right? If
I see.
the president can, any day he wants, he can create a new officer position in the or the executive branch, and he can appoint someone into that position. But their officer in that case is not actually created until the Senate confirms it. So that's like channel one. Channel two is Congress says, we hereby authorize and provide the money for a new federal agency, the Department of Bad Judges or whatever. And we grant to the Attorney General the authority to pick the leader of that. And if that passes Congress as a law, then the Attorney General has the authority to put someone in that role, and that person qualifies as an officer of the government, a principal or subordinate officer of the government, depending on how much authority they have.
And because the law comes from Congress, then you have not usurped or surpassed or circumvented Congress's role and separation of powers, et cetera, et cetera.
That's exactly right. So in one case, the president can do it. In another case, a non-president can do it, but only after Congress passes the law. And the reason for that is like the separation of powers issues means that both the president, who can appoint officers on his own, is accountable to the public through the political system, and Congress is also accountable to the public through the political system. And so,
yeah, and I think the term is advice and consent of Congress, right?
You can't, like, as a government, as a head of an agency, you can't just go around creating positions and putting people in them, because that would be usurping this function that is specified by the Constitution to rest in the hands of the president or in Congress after they pass a law. So that's kind of what she's saying. I know that's kind of hard to, that's a bit down in the weeds, and I apologize for how confusingly I laid that out. But
no,
that's what she's saying.
It's good to have clarification there.
Yeah. So for this situation, though, Channel 1 doesn't apply because Jack Smith never made the argument, hey, I was appointed by the president and confirmed by the Senate.
Right.
Because of course he wasn't. So that disregard that whole way. So the whole thing is focused on, did Congress pass a law that gave the Attorney General the authority to appoint Jack Smith?
Right.
And her conclusion is no.
Right. And so that's why she's dismissed the whole case.
Exactly. She also goes on to later conclude that the funding was fugazi and doesn't pass constitutional muster, but it doesn't matter because she'd already booted the case, so it's not,
right. But now the 11th Circuit will have to also consider that because she brought it up.
They will.
And I want to talk more about some of the other things that she cites and reasons that she cites, but we do have to take a quick break. So everybody stick around. We'll be right back.
Welcome back. Okay, so before we move on, I'm going to just beat this dead horse a little further because I think it's really interesting when you get into the nitty-gritty on how she attacked Jack Smith's argument. It exposes, I think, some of the contradictions that I think will be very relevant on appeal. These are the sorts of things that Jack Smith's going to point out to the 11th Circuit when he's now going to be trying to argue that she's wrong. So in his papers, the special counsel relied on, if we talked about Congress has to pass a law that gives the Attorney General the authority to make this appointment. And so Jack Smith pointed to a law that's at 28 USC section 515. And it has two sections, A and B. And she really goes deep on, this is really the meat of Jack Smith's argument. And she really goes deep on saying like how wrong he is here. But there's a couple things that I thought were worth pointing out. One, she says there's no law that grants this authority to the AG. Well, there quite obviously is, and it's 28 USC 1515. Section A reads, the Attorney General or any other officer of the Department of Justice or any attorney specially appointed by the Attorney General under law may, when specifically directed by the AG, conduct any kind of legal proceeding, yada, yada, yada. It just goes on to say what authority a specially appointed attorney would have. So clearly,
there is a
Congress intended to give the Attorney General the authority to appoint a special attorney because they say it in this law. So
this is 28 U.S. Code Section 515, authority for legal proceedings, commission, oath, and salary for special attorneys. And this is law, a statute passed by Congress. Am I right?
Exactly.
And it specifically says, or any attorney specially appointed by the Attorney General under law.
Right.
Maybe she's like, well, under law, what law? This law?
That's basically what she says. She goes on and on saying how this doesn't really count. So Section A, as we just mentioned, specifies what a special attorney can do. Section B has more kind of like specifics in it about how the special attorney must take an oath. And it also goes on to say foreign counsel employed in special cases are not required to take the oath. And that makes sense because if the AG was compelled to appoint a foreign attorney, you're not going to make a foreign person swear an oath to the U.S. Constitution. Right. So the crazy thing is she claims that this law, one of her arguments is that it doesn't apply to attorneys who were appointed from outside of government. But yet the law itself presumes that it is okay to appoint foreign attorneys who by definition don't work for the Department of Justice.
Well, he's not foreign either, Andy. So any non-foreign, non-government employee isn't covered by this statute.
Maybe, but you could make the argument Jack Smith was kind of foreign because he was living at The Hague at the time he got appointed. Yeah. But I mean, it's just so ridiculous. She goes on and on about, she says, Section B is logistics only, and it only applies to special attorneys already retained under the old expired independent counsel law. That's how she interprets. She's saying because they use the word retained, past tense, they meant, and when they drafted this law, that it only applies to special attorneys who had been appointed when we previously had an independent counsel law. But none of that is anywhere in the statute.
And that doesn't make sense. Retained means
have been
25
appointed.
Years ago?
Retained could mean they were just appointed 5 minutes ago. Anything is past tense. Like the retained, it's mentioned in the context of a lawyer who has been retained, then has to take an oath. Well, of course, you only take the oath after you've been appointed or retained.
Andy, everybody knows that it has to be more than 25 years in the past in order to be past tense. Everything that happened within the last 25 years is present tense, right?
It's just so crazy.
Wow. I mean, so she's busting out Webster's dictionary on past tense and participles and oh, wow.
Totally. Yeah. And she relates all this stuff with like a super high degree of confidence. There's a bunch of what you would expect, kind of snarky, very conclusive, dismissive references to the special counsel's arguments and things like that. And okay, to be fair, like judges do that kind of stuff. They're a fairly superior crowd, or they think they are. So, I just think that keep hope alive on the appeal, because I feel like there's a lot of this reasoning, even though it's long, the strength of a judicial ruling is not measured by the weight of the paper that it takes to write it.
Long doesn't mean good.
Exactly. It's just like school, right?
If I had more time, I'd have written a shorter paper.
If I'd had more time, I would have gotten a better grade, I guess is her theory.
Well,
but
I would have gouged my eyes out before reading this, is what I would have done if I had more time.
And I don't recommend reading it. It is an eye gouger, but
it's a brain twister too, because she's going around she's really twisting herself into knots.
Yeah.
To make this a reality for Donald Trump.
Yeah. I mean, I got to say, that's what it looks like. It's, although, yeah, well, I'll hold that comment until we're kind of at the end.
Because I'd be interested to know if she says this doesn't apply to attorneys from outside DOJ, but the special counsel regs say that they have to come from outside the DOJ. What sort of attorneys appointed by the Attorney General are they talking about in this law? What are they talking about if not independent and special counsel?
Yeah. I mean, I can't, it's hard for me. It's hard for me to try to figure out how she would explain that, but
I know.
It's
bizarre.
There's a lot in here that I was reading all this on the train on the way back from New York this morning, and the train is like really bouncy when you're trying to read. I don't know if you've ever noticed that. You're just kind of like, so I'm reading this obtuse 93-page ruling and it's bouncing around in my lap. I was like, I feel like
it probably
I have to
makes
vomit.
more sense if you skip certain lines and go backwards again because of the train bounce.
Maybe it makes more sense if you drink while reading it, but I was not doing that. So
yeah. And so a couple other things, we talked about whether this impacts other cases. She specifically said the effect of this order is confined to this proceeding. It does not. But that doesn't stop other people from filing based on what she says. But district courts don't set precedent, right? Like you said.
That's right.
Hunter Biden's special counsel was confirmed by the Senate. David Weiss was confirmed by the Senate. So this, I don't think, would apply to him, right?
That's correct.
Her whole point is that you have to he's circumventing the power of Congress.
Yeah.
And again,
which is kind of crazy because none of those people were confirmed for their special counsel job.
No,
they were confirmed to be U.S. attorneys.
Right? Durham, Weiss. Yeah. Now, Robert Hur could run into a problem, but that horse has left the barn. Doesn't matter. Biden was exonerated, and all the terrible political crap that he shoved in that report that was completely untrue and contradictory to things that he said in the transcript in the interview. It's already out. The horse is out of the barn there.
Yeah.
But there's no 11th Circuit precedent, but there is Supreme Court precedent. Right.
Yes.
And others who have challenged the special counsel's authority include Hunter Biden, Paul Manafort, Roger Stone's associate, Andrew Miller. Remember him?
Mm-hmm.
And of course, Concord Management tried to get Mueller thrown off the case too. There are tons of recent examples and many that go even further into the past. None have ever said, oh yeah, the special counsel is unconstitutional. The idea of a special counsel not confirmed by the Senate is unconstitutional. And of course, as we expected, Cannon repeatedly cites Justice Thomas's immunity concurrence. But as Anna Bauer points out, she's dismissive of a passage in the Supreme Court's unanimous Nixon opinion because the issue was not briefed or argued before the court. Bonkers. Right. So here's a couple of excerpts from the ruling here. To the extent Special Counsel Smith insinuates that under law in Section 515A does not require what it plainly says, that special attorneys must be appointed by the Attorney General under statutory law, no basis is provided for that atextual suggestion. Yes, it is. She goes on to say in another section here, first, Nixon does not engage in any statutory analysis of the cited provisions. Although Nixon, quote, gave passing reference to the cited statutes. Okay, that sounds like a reference. The opinion,
like they engaged in some statutory analysis there, but okay.
Right. Even though they mentioned it, they didn't really mention it for long enough. I've got 93 pages. I don't see 93 pages on the analysis here. She says the opinion provided no analysis of those provisions. Text. So, and that's Thomas.
That's a quote from Thomas's concurrence. Yeah.
And following a comprehensive review of the Supreme Court record, the court concludes that the disputed statement from Nixon is dictum. The issue of the Attorney General's appointment authority was not raised, briefed, argued, or disputed before the Nixon court. So that's why Anna Bauer pointed out that, even though she cites Thomas's immunity concurrence, she completely ignores the Supreme Court's unanimous Nixon opinion. And she says it's because the issue wasn't briefed, argued before the court, and Thomas said it wasn't really fully analyzed. Like, it's, even though they mentioned 515, it wasn't fully analyzed. Unbelievable.
You know what is dictum? Thomas's concurrence, because it has to do with an issue, to quote Judge Cannon, that was not raised, briefed, argued, or disputed before the court. That issue was not raised. The court did not agree to hear that issue. Nobody briefed it. It wasn't argued. It was just Thomas taking a drive-by at Jack Smith. I mean, that's all it was.
And honestly, the entire immunity opinion is dictum because it has nothing to do with what the circuit court decided. I mean, that's why I was, on a Friday night, because I like to party, that's why I was writing up mock Supreme Court rulings that the whole stay would be denied and they wouldn't take up the case. Because that's what happened in Thompson, right? When Benny Thompson wanted to get a bunch of papers for the January 6th Select Committee from Trump, and Trump said, I have executive privilege, I'm privileged, you can't have my documents. And the circuit court said, even if you had the privilege to exert, which you don't, we still wouldn't. It's still no good because law enforcement and this investigation takes precedent over your privilege. Yeah. And so the Supreme Court said, we're not going to take up this case because, dicta, it's moot. We don't have to decide whether you're privileged. We sure would love to. We would love to set a rule for the ages about executive privilege and whether former presidents' documents are considered executive privilege, but we can't because that's not what the circuit court found. And I could have sworn that's what they were going to do in this immunity case too. We would love to set a rule for the ages and make up a whole new thing about future presidents' immunity, but we can't because we are restricted to determining whether or not what the circuit court held, which is this case only, was correct or not. They didn't do that. They ignored dicta and they went ahead and created a rule for the ages that had nothing to do with what the circuit court did. But now you're bringing it back down to this very granular level where Judge Cannon is saying, I can't, Nixon we can't talk about because they didn't brief or argue. But she's relying on Thomas's concurrence, which was not briefed or argued. That's bananas.
That's the kind of thing that I think will be very impactful on the 11th Circuit. She's ignoring a very clear, unanimous Supreme Court decision that is directly relevant to this issue and embracing Thomas's dictum and a concurrence that no one else joined on an issue that was not before the court, was not briefed, was not argued, was not decided.
Or analyzed.
So I think, it's so obviously wrong. I kind of feel like in their last two handlings of her mistakes, they didn't hesitate to slice and dice through the mess that they thought she made. And, let's hope the same thing happens here.
We'll see. We'll see what happens. We do have to take another quick break. We have more to discuss. We'll be right back. All right, everybody, welcome back. So let's talk about the options for this case now. It has been fully dismissed, the entire superseding indictment, all of the charges against all three co-defendants. So what are the options for the Department of Justice? Our CIPA expert, Brian Greer, laid them out pretty perfectly on Twitter. If you're not following Secrets and Laws on Twitter, you ought to be. He says the Mar-a-Lago case was never going to a jury with Judge Cannon. So other than the political gift of the timing, which is lined up right nicely with the RNC, or as some people might think, political gift on the timing because now everybody will shut up about Biden's age and the shooting at the Trump rally. Not sure which he means. But today's development, he says, merely accelerates the process of DOJ figuring out the next steps. However, he says there are no quote unquote good options here for Jack Smith. The question is, which is the least worst? He said, I'd start from the premise that Smith appealing and not asking her for removal may be the worst option. She's proven she'll do everything she can to tank the case for Trump, but asking for her removal is a pretty dramatic step, one that the DOJ will not take lightly. This would be the second time she's taken an appealable, fairly lawless step, so maybe it's enough to get her removed, but she'll just say, hey, the Supreme Court justices agree with me. And I think that's where what you're talking about, Jack Smith's argument about dictum, will come in.
Yep.
As others have noted, he said, filing a new indictment from the U.S. Attorney's Office for the Southern District of Florida is also an option, because if you have the U.S. Attorney in Florida file the indictment, you no longer have to contend with the fact that the person who's filing the indictment was not confirmed, or advice and consent of the Senate or Congress, right? Because the U.S. Attorney was. But if it goes to Cannon again, which is likely, what have you accomplished? And she'd likely need to do something again to ask for removal, like you're starting from scratch. And I haven't, Andy, I've got my feelers out there. I haven't gotten a direct answer from clerk of the court or from any experts like Charlie Savage, who wrote this up for the New York Times last year, about the odds, right? Because the odds in 2023 were 1 in 4, and it had a lot to do with the fact that multiple senior judges in that district had reached their quota, because when you're a senior judge, when you go to senior status, you only take a certain amount of cases per term.
Yes.
They had all reached their quota, so they were no longer in the running, right? Pull all of them out. There was another judge that was on vacation. And then there was another judge, Middlebrooks, I think, who was only taking cases in the very heavily trafficked, I think, Miami district. And so he wasn't in the running. And so you ended up with a 1 in 4 chance of getting Cannon in 2023. And that's and we got Cannon. I don't know what the odds are right now. I don't know what the senior judges' quotas look like and caseloads look like right this minute. I've got the question out there, and we'll keep you posted as far as that goes. But that would only come into play if you were going to refile through the U.S. Attorney's Office in Florida.
Right.
He goes on to say, the third option I'd float is filing a new indictment in D.C. As we've previously explained, you, me, and Brian, Andy, when we talked to the Schar School at George Mason, or we've talked about it on this show, this indictment could not include the Espionage Act charges. There's just no legal basis for venue in D.C. And the immunity decision also makes that harder, because he was president when he left with the stuff. This new D.C. indictment would be narrow and would focus only on Trump's obstruction of the grand jury subpoena. Not his obstruction about the videos and flooding the thing and deleting videos of him obstructing justice, right? It would just be obstruction of grand jury subpoena. There is a legal basis for bringing this case in D.C. if brought under 18 U.S. Code 1512 or 1515A. The official proceeding includes a grand jury.
That's
obstructing
right.
an official proceeding.
That's right.
Mm-hmm. He says there's a question of whether the statutory venue provision is constitutional. In U.S. v. Try in 1998, a district court permitted a case like this to proceed. There is some earlier D.C. precedent to the contrary, but Congress amended 1512's venue provisions after those decisions. He's talking about changing venue to D.C. And under the recent Supreme Court case of Smith v. United States, there is an argument that a venue challenge from Trump would not be appealable until after the conviction, so it wouldn't be interlocutory. But would this Supreme Court agree? Probably really hard to say.
Where you want to, I wouldn't be confident betting against
No,
that
me
one.
neither. I can't say with any clarity what the Supreme Court will do from here on out. But as Chuck Rosenberg said on TV this morning, on Monday morning, DOJ would be reluctant to pursue the option of bringing the case in D.C. for the perception of judge shopping, given the perception that they would be judge shopping. And Brian Greer shares that concern. The argument in favor is that Cannon and the Supreme Court, with their immunity decision, have changed the legal landscape. So we're not judge shopping. The whole legal landscape has changed with her dismissal and with the immunity ruling.
Yeah.
He says, remember, the Espionage Act charges are really DOA with Cannon after the immunity ruling. Even if the case goes to someone else. I think the Department of Justice would prefer to narrow its indictment somewhat to focus solely on Trump's failure to return the docs and obstruction of justice. So even if DOJ pursues option 1, appeal and removal, or 2, refiling in Florida, they will want to narrow the allegations of the indictment somewhat to focus squarely on his failure to return the docs after the grand jury subpoena, while still keeping the Espionage Act charges. And finally, filing a new indictment, either in Florida or D.C., would raise questions about interference with the presidential election. Even though we're outside the mythical 60-day window, DOJ didn't create this situation. Judge Cannon did. But the perception of playing politics is actually there. It's real. So he says, sadly, none of these options are good. They're all bad. And likely the question is, well, which is the least worst? It's a very tough call, but I'd likely pursue option 1, appeal and removal, and then still narrow the indictment allegations if and when the case proceeds. Well, Brian, we have a statement from it's from Peter Carr,
yes,
spokesman for Special Counsel Jack Smith's office specifically, not the DOJ. Andy, what does that statement say?
Yes, and Peter Carr says, the dismissal of the case deviates from the uniform conclusion of all previous courts to have considered the issue that the Attorney General is statutorily authorized to appoint a special counsel. The Justice Department has authorized the special counsel to appeal the court's order. So there you go. No time wasted.
So they're going to appeal.
We don't know if they'll also ask for the removal. We'll have to see how that comes out. But
yeah, that'll be interesting. But what you pointed out to me before we started recording was the little sentence, the Justice Department has authorized Jack Smith to do this. Talk about why you think that's important right there.
I just thought it was funny because part of the sorry for that noise. That was my dog shaking his head and making all kinds of noises.
It's okay. Hi, Bupper. Because isn't Cannon trying to say that he's too independent or whatever?
Yeah. So when you get into this, is he an officer or is he an inferior officer? Trump had argued if he's an officer, he had to go through Channel 1, appointed by the president, confirmed by the Senate. If he's an inferior officer, he has to be adequately supervised by a superior officer. And, Trump argues that he's not supervised. Well, I think that this statement is pretty good evidence that he's supervised by the Attorney General, since he had to get the Attorney General's authorization to pursue an appeal. Right? And
wow.
That's the argument that Jack Smith made in response to Trump's nonsensical, you're not really supervised by anyone. He is, of course, supervised by the AG.
Kind of a little peephole into what he's going to appeal with, right?
Yeah, there's no question. And it'll be interesting to see if they refer actually to that authorization in their motion, but they certainly could. I mean, it's an artful way of throwing that in there. I think also, this is for me, before we saw the statement come out, I was already in category 1, like appeal it and go swing for the fence, try to get it removed, because I do think that there's significant grounds for appeal here. They've gotten treated well by the 11th Circuit in the past, so the circuit knows kind of how bad she is and how many bad decisions she's made before. There's now a pretty long record of not only like questionable decisions, but also like pretty bad treatment, I think, of the special counsel and his attorneys in court.
And the law.
And of course, the law is on our side. I think she's made a very pretty clearly wrong decision here. And when you put that wrong decision on the backdrop of the way that she's treated them, it all starts to look a little bit more like true bias, right? You can't just go in and say, oh, we want her removed because she makes decisions we don't like. That's never going to get you there. You got to really make this case for bias. And I also think that the information that we found out about how she totally ignored these 2 other senior judges in the district who recommended to her that she recuse because of the obvious like appearance of conflict that she has to deal with because of her own history on this case. That's another factor that I think would be relevant to the 11th Circuit. Like, what's going on in her head a little bit? So,
yeah, I think so too.
That's what I think.
I think so too. I think we'll see mention of this case, obviously, and how this is wrong on the law. The statute is pretty clear, and there are, not necessarily in the circuit, but elsewhere, 8 other times, other federal judges have upheld this. I think we'll see her clear error and manifest injustice on wanting to release the witness names, using a wrong standard for keeping those things under seal or not keeping those things under seal. And he had to file a motion for reconsideration, which she adopted and said, oh, okay, you're right. You're ugly and I hate your face, but you're right. Because she always has to take a couple of shots at the special counsel when she grants him anything.
Yes.
I think he'll bring up that. I think he'll bring up, like you said, I think he'll bring up a lot of Trump's public praise of this particular judge. Although I'm not sure that really makes that much of a difference because you can't, it's not, I mean, it's kind of like how it's like a totality of evidence, kind of how Mueller brought up all of the pardon dangles to Cohen,
exactly,
Manafort, stuff like that. And then, of course, as you said, those two judges, and this one of them being the senior judge who called her up and said, you should probably not be on this case. And she ignored that. And then, of course, the special master debacle. I think you've got those things that you can bring up and argue for a totality of evidence for removal. And then, of course, maybe just the inexplicable delay. There are 9 undecided motions on this docket when it was dismissed. This motion took 144 days. It was filed last February. It's July. So that might be there too, because I know Jack Smith and Jay Bratt have mentioned that this is just for delay's sake in several other filings. So I think that might be a 6th thing that they could bring up. But now we have confirmation of all of those options. We have confirmation that they will appeal. I don't think that appealing necessarily stops them from refiling in a different or refiling with the U.S. Attorney's Office or in a different jurisdiction. But it seems probable that they won't, that they're going to go for this appeal first, and we'll see what it looks like. I don't happen to know how long they have to appeal this decision. Did she put that in her order, or is there some local rule?
I don't remember seeing it in the order.
Yeah.
It's probably a local rule thing. It's usually some limited period, like 2 weeks, maybe 30
I bet we'll
days
see
at
it fast,
most, but I think it'll be quick.
I think they might have already had it written. We kind of all saw this coming, right?
They haven't had anything else to do, so I think that I don't like the DC option at all. I think that really narrows the case and puts it on shaky ground. The refiling in Southern Florida is an interesting question, but I tell you, I don't know that I agree with Brian on the necessity of narrowing the scope of the charges. He seems to be really be behind that idea, which is fascinating, and I'm sure we'll get to talk to him about that at some point.
Particularly on the espionage, and I think it's because that if this case goes to Judge Cannon again, you and I have talked about the fact that the espionage charges should still stand because they have to do with retaining national defense information after he was president, not taking it from the White House while he was president. However, I don't know that would necessarily bar Judge Cannon from seeing it differently and saying that because he was president and his official acts are immune and he left with all of these papers as an official act, nothing now can be questioned or indicted or
she could definitely I could definitely see her taking that position.
So I think that's what Brian's getting at.
Yeah, and I understand that, but I would appeal that immediately. I think it's dead wrong. He's not the president when he leaves town. And, I guess in his case, he left an hour early or something like that.
That's why he left early, yeah.
And he's not retaining them as president. There's nothing official about his status at Mar-a-Lago where those documents were kept. So to me, that's a case, I'd be comfortable sending that question to the jury. I mean, so I don't think you have to. And to cut all that stuff out of here, I think really does an injustice to the case and to the charges. This is not just a case about obstruction. It's clearly that's a big part of it. But man, this is about somebody putting the nation's most sensitive secrets at risk. And I feel like there's a real equity that needs to be protected there.
Yeah, I agree. I just don't trust the Supreme Court not to rule in favor of him leaving with the documents is immune and an official act, and therefore anything that followed it is not questionable.
Yeah, but, that's a risk. That's a risk.
But that would also mean that the obstruction is not questionable, that you can't, because you can't obstruct documents that are legally yours or whatever, right? So
I think it turns into a fruit of the poisonous tree type of argument. Well, if he did all this as president, it was an official act, then you can't use any of it.
Yeah, it's either all or nothing. I would assume in an immunity discussion with Judge Cannon. All right, we have one more quick break. Just a couple more things to talk about. Everybody, stick around. We'll be right back.
Welcome back. So here's one that I wasn't expecting. Lindsey Graham. Didn't think you'd hear me leading off with Lindsey Graham in a Jack topic, but here you go. Lindsey Graham today said that Judge Cannon's decision is right on the law and makes sense to me, which is weird, AG, because in 2017, Graham co-sponsored a bill to protect special counsels from executive interference. And he specifically called for a special counsel outside the DOJ to investigate Hillary Clinton's email. So it's okay, I guess. It's okay as long as the special counsel is investigating Hillary Clinton.
God, does he even remember the stuff that he says? This is recent. I guess, 2017 was a while ago, but this isn't Nixon.
Come on. I don't think it doesn't matter. I think that it just doesn't matter. In the olden days, ye olden times, to be accused to be being a flip-flopper was that was bad stuff in politics.
It was bad stuff.
You remember? That's what George Bush used to say about Bill Clinton. He's a flip-flopper.
Yeah.
Now, you can flip and flop all you want. Makes no difference. There's no memory of anything anymore.
Nobody has time to cover it because... gestures broadly. There's so many other things going on. But I also wanted to, before we got out of here today, I noticed, and I know you noticed this too, that not only did Judge Cannon cite Clarence Thomas's concurrence, which was, dictum, in her 93-page ruling that it goes all over the place. It's very hard to follow. But also, she cites a lot of the other conservative justices. Oh, yes, she does. Doesn't she?
Oh, yes, she does. In fact, on page 11, she cites one Brett Kavanaugh in a law review journal from 1998. So I guess when you are looking to avoid having to refer to the unanimous Supreme Court decision in U.S. v. Nixon, you just turn instinctively to law review journals written in 1998 by then young lawyers who are now prominent conservative justices on the Supreme Court. And on page 17 in the...
and by the way, that Brett Kavanaugh law review article, he was recommending that Congress amend the statute that would authorize the president to appoint a special counsel with advice and consent of the Senate. Right?
Yeah, which is actually a lesser degree of congressional input because advice and consent is not approval. You don't have to vote, I don't think. I think advice and consent is a little bit quicker. It's not quite the same excoriation of a full-blown hearing.
Well, I thought it just meant you have to pass a law or confirm or whatever.
But I think it's, you clearly see I haven't read that law review article, and I absolutely will not. but
you're not going to go out for your free time and read a 1998 Kavanaugh article?
I don't think so. I tend only to read Kavanaugh post 98.
I see. Yeah.
I think that's the direction he's going, is trying to make it easier to appoint special counsels. But in any case, and then flash forward to page 17, where she has another footnote that says, see Amy Coney Barrett, substantive canons and faithful agency. Yet another law review article, this one from 2010, at least it's in the right century. And the piece in that article that Judge Cannon is citing is actually something that Justice Barrett was citing one Neil Gorsuch. So that was a 2-for-1 pandering. That's two. You get two in the same footnote.
And I've got an Alito reference here on page 87. The appropriations clause, this is where she's talking about the money that's moot, but she's going to talk about it anyway. The appropriations clause plays a critical role in our constitutional scheme of separated powers. It is Congress, not the executive or judicial, that controls government spending. Any exercise of a power, quote, granted by the Constitution to one of the other branches of government is limited by a valid reservation of congressional control over funds in the Treasury. As a historical matter, Congress's power over the purse has been the most complete and effectual weapon to ensure that the other branches don't exceed or abuse their authority. And that's Alito in the CFPB case, which he, and that's a concurring opinion. That's the Consumer Financial Protection Bureau when, they were trying to say that it was inappropriately funded. And as we know, special counsel is funded by a permanent fund in the U.S. Treasury, right? So that's kind of where they're coming at from this. So I found an Alito, and we got a Gorsuch, and we got a Barrett.
Bingo.
And
you sunk my battleship.
And we got the Kavanaugh, but we don't have a Roberts, which is interesting.
I didn't see one. I'm gonna have to go back and do some text searches. But yeah, if you want to play Supreme Court Battleship, then you can, as you find other sites to our conservative majority on the court, please send them into the question line.
Right. And she did quote Kagan on the appropriations in a
footnote. It's name dropping on both sides, right? You want to put as many as you can in there because under the assumption that all your decisions are probably going to be reviewed.
But no Sotomayor, and I'm looking for Jackson. Nope. No Jackson.
No Jackson. Well, there you go. It is in some ways, it's a incredibly frustrating result. It's tough to read, but there's some fascinating little nuggets in there. And I guess my overall sentiment is I think that the special counsel's office is doing the right thing by appealing it. I hope they add the request for removal. And I think that there are good cases to be made on both of those fronts. So we're going to hang in there and see where it goes.
I bet we'll see it maybe by the time we record the regular episode on Friday. If not, we'll definitely cover it on the subsequent week or weeks, depending on when this filing from special counsel comes out. And
it's possible the first thing we'll see is just a notice of appeal, and then the briefing schedule kind of follows that. But we'll see what happens.
Yep. We definitely will. And of course, we'll might be loath to cover Trump's response, but we will here on the Jack Podcast. Thank you again for listening and supporting the Jack Podcast. I know there's a lot of noise in the media out there right now. And so I think I can speak for both of us, Andy, when I say we're just really honored to be able to bring this important news to you in these extremely important times. And, we'll be back in your ears on Sunday. Do you have any final thoughts before we get out of here for the week?
Yeah, just I echo your sentiments there. I think it's a total privilege that people rely on us as a source, as a reliable source for this information. And so deeply appreciate that. And also been a really tough couple of days with all the events over the weekend and everything. And I know that it's a lot of stress having to kind of like constantly reevaluate the state of the world like every 15 minutes as these things like this happen. And it's good time sometimes to kind of tune out a little bit and take care of yourself, step away from the flame if you find that coverage of all this stuff like the attack over the weekend and everything else really can be a little overwhelming. So kind of keep an eye on how you're doing out there.
Yeah, 100%. Listen to your, mindfulness, practice some mindfulness and get out there and do something that's fun. For me, appealing to the 11th Circuit is fun, so I'm covered.
You're good. You're loaded.
But we'll see what happens. Maybe I know that it's hard to put positive spins on any of these things that are that are going on. But with this in particular, we do get to go to the 11th. We will get to see an appeal, and we'll bring it to you here on the Jack Podcast. Thank you so much again for listening. I've been Allison Gill.
And I'm Andy McCabe.
Good bonus episode, friend.